What's up, everybody? Stuff's happening in the Karen Reed case, and I know that there is so much going on in the background and so many wild twists and turns of this case that are unbelievable if you weren't following it yourself. And we had a bunch of comments in the last video that this guy has no clue what he's talking about. If he doesn't know all of the facts of this case, he can't talk about this case. And that's exactly the point. We don't want to know all the facts at this point. We don't want to know what everybody says the facts are, what everybody swears the facts are, what everybody's going to the ground about what the facts are, fighting back and forth about it, as happens in so many cases, because we're going to go into this trial. If it does happen, a lot of you are saying, oh, it's not even going to go to trial, so that's going to be a waste. Well, if it doesn't go to trial, there's not going to be a ton for us to talk about, because to speculate on who's right, who's wrong, who's hiding what is difficult when you're not in the situation and know all of the scenarios of who's saying what, who's credible, who's not, where this case may be going. So I get that. I get it. I understand it, but that's not the type of coverage we're going to have on Karen Reed. We've done it on a bunch of other cases. We'll continue to do it on a bunch of other cases, whether it's Murdoch or Koberger or whatever else that we're following before trial and really digging into the facts, digging into discovery. But we can't do that on every case, obviously, right? It's only a certain amount of time that we have in the day to break this stuff down. But when people sent me some very interesting circumstances that are unusual, that I have not seen in a lot of cases myself, with this back and forth between the state attorney's office and the U.S. attorney's office, potential investigations, where state attorney's office and law enforcement can call defense attorneys conspiracy theorists, slinging mud against the wall just to see what sticks. They got nothing. It's all baloney. But when the U.S. attorney's office starts looking into it and the district attorney's office tries to block that investigation potentially, then we have to understand this is more than your average pointing the finger at a bad investigation, which we've literally seen in almost every trial, whether it's Melly or Murdoch or Rittenhouse or whatever it may be. We've seen so many allegations like this, very few rise to this level. And it's really a perfect case to bring my dad in on to discuss what's going on between them. And today, so we talked about the hearing as to whether or not these letters should be released. We all unanimously basically thought they should, including the U.S. Attorney's Office themselves. And I think the state basically withdrew their objection, allowed the letters to go public. And now we have 8 letters to review from May 9th of 2023 to November 22nd of 2023, I believe, are the date ranges of the letters. We are going to read through them together today. And I'm going to bring my dad on and we are going to break down each letter, what it says, what it means, and how unusual this is and how it makes each party look. Dad, when you were reading the letters, what's kind of your overall thought of having a back and forth like this? Were you surprised to see it, or is it pretty much what you expected?
I am surprised to see it only in it's unusual. District attorneys don't usually write letters like this. They don't say things like this. District attorneys also know that it's almost a total waste of time. So yeah, it's unusual for this to happen, but the U.S. Attorney's Office is doing exactly what I've expected them to do.
Yeah, and there were some things that were surprising, other things that weren't. I'll save it for when we actually go through the letters, because when you get in a situation like this, there are some jurisdictions, right? Like, so you assume, and based on our last video, the U.S. attorney is obviously a higher position, higher authority than the state attorney, but there are certain jurisdictions where the state attorney's been around a while. The U.S. attorney either hasn't or is on their way out or is brand new, where the U.S. attorney can have a little more weight to throw. I'm sorry, the state attorney sometimes can have a little more weight to throw around than the U.S. attorney, depending on the jurisdiction. Although unusual, it can happen. And it seems like maybe that's something in the background here that this district attorney thought he had the upper hand on the U.S. attorney that I believe was on her way out, right?
Right.
All right. So let's pull up these letters now. I can never remember what the best view is with 2 boxes. Let me see. And I'm going to try to do them in date order. A bunch of people sent me these, so thank you to everybody that sent these over to me. Here we go. All right. So we are going to zoom in a little, and I'm going to start with, they go to January 12th, I should say, of 2024 was the most recent one. But we're not going to start with this one. We are going to start with May 9th, which is, I believe the first letter, May 9th, 2023 is the first date I have. We can figure it out as we go if I'm wrong and correct those dates. So we're going to read through these, see what we can find out, see what we can learn from these letters. All right, this is from the Commonwealth, Michael Morrissey, who is the DA. This is to Joshua Levy, First Assistant U.S. Attorney. Do you want to talk about what the first assistant is? I guess let me give background. Anybody that's new to the channel, we're lawyers in Florida. I mostly practice civil litigation, civil trial lawyer. I've done some criminal in my past. My dad's basically only done criminal, was a former state attorney, former U.S. attorney, former chief assistant U.S. attorney in charge of the criminal division who would handle things like this if it was going on in the criminal division of the U.S. attorney's office in the Middle District of Florida. Now, obviously, private criminal defense attorney for the last 30 years. Do you want to explain who the first assistant would be in most U.S. attorney's office?
Sure. First assistant is what most people also call the chief assistant. You have the U.S. attorney, and right under him, first assistant. He basically runs the day-to-day operations. Now, interestingly enough, as we're going to see, Jason Levy is first assistant, but is also not unusual. Apparently, the U.S. attorney gets removed from office there. Jason Levy then becomes the acting U.S. attorney. You'll see him sign, and you'll see his name that way in other letters. And so it's not unusual for the first assistant to be promoted as an acting U.S. attorney when the U.S. attorney is absent, and that's what happened here.
And you'll see a lot of assistant U.S. attorney. Oh, my dad just left the room. He'll probably be back, hopefully. So whatever you clicked, Dad, don't click that again because it removed you from the thing.
So happened. Okay.
You'll see a lot of assistant U.S. attorney, assistant district attorney. There are a ton of line assistants, right? Depending on the jurisdiction, I should say. So all of those assistants are just assistant U.S. attorneys or assistant district attorneys or assistant state attorneys. The chief or the first assistant has that title because they are number two. It's not like there's a first assistant, second assistant, third assistant, fourth assistant. The first assistant is basically the only one that gets that title usually.
Right. There's only one first assistant.
I write to follow up on our conversations regarding the issuance of federal grand jury subpoenas to at least 2 witnesses to the Commonwealth's investigation into the death of John O'Keefe. As you know, indictments have issued in Norfolk Superior Court and the prosecution is ongoing. As a prosecuting agency, the Norfolk District Attorney's Office has the constitutional duty to provide the defendant with exculpatory evidence. The obligation in Massachusetts to provide exculpatory information pursuant to Brady v. Maryland and its progeny means not only the constitutional obligation to disclose exculpatory information, but also the broad obligation under our rules to disclose any facts that would tend to exculpate the defendant or tend to diminish his or her culpability. Under the Massachusetts Rules of Criminal Procedure, mandatory discovery includes all facts of an exculpatory nature and all statements of witnesses. To effectuate our discovery obligations, we are requesting at the earliest possible opportunity discovery of all statements of witnesses to the investigation of the death of John O'Keefe and the resulting prosecution, including both statements to investigators and grand jury minutes. The Commonwealth also has the duty, at the time we become aware of that the statements of the witnesses exist, to notify the defendant of the items under Rule 14 that the prosecutor knows to exist, but are not within the care, custody, or control of the prosecution, to provide all information known as to the item's location and identity of the persons possessing the item. So just with page 1 here, they're trying to do what they're trying to do here is ask for all of the information they're getting in the grand jury investigation because they want to turn it over to the defense, because they really care about getting exculpatory information, right? That's what he's trying to make this letter sound like.
And it's a joke because he knows the U.S. Attorney's Office cannot hand over the grand jury material to him. He knows that. And later on, you'll see where in this same letter, he admits he knows the rules don't allow for that. So this is just a publicity stunt.
But again, it's cloaked in making sure we protect the defendant's rights.
Oh, sure.
That's what we're here to do. Thank you, Azam, for gifting a membership. Netwoman said, I can't believe that we have letters. They aren't from Sarah Boone. Thank you, Papa Tragos, for joining in and explaining this also. You both rock. Yes, letters from lawyers. Letters from lawyers. That's what we have here. All right, let's keep reading here. We appreciate the sensitivity and need for discretion as to any ongoing federal investigation. While we are unaware of the parameters of the federal activity, we cannot forego our constitutional or state duties. So they're basically digging here. They're poking around, trying to figure out what's going on with the feds.
I mean, they're scared. This just shows that they're worried.
While we are we are willing to file a motion for a protective order under Mass Crim Rule 14A6 to request limitation of the disclosure of the information to defense counsel only. Any decision of such request, of course, is solely within the authority of the Norfolk Superior Court judge. Similarly, we are willing to facilitate the process or to a request under Fed Rule Crim 6E3EI or 4 for authorization from a federal district court judge for production of the grand jury minutes and related material, if any. Additionally, this office has constitutional and state obligations to provide exculpatory information of which we are aware in all cases, including exculpatory information relating to all witnesses and or members of the prosecution. This would include any investigations into misconduct. There's the little zinger. He's like, oh, and by the way, if there is misconduct, that could be exculpatory or something that the defense could use in this case. We also have a duty to disclose that, so please let us know if you have any of that. If any such information exists, it is imperative that we learn of it in a timely manner. In sum, while we appreciate the notification that subpoena is issued, it is imperative that at the earliest opportunity we are able to provide discovery to the defendant.
You know, Peter, I know that you have done this in many other cases, but, you know, not to gloss over it, but in the very beginning, they cite Brady versus Maryland.
Yeah.
And that we've seen that in almost every criminal case we've talked about, because that's the case that requires the government to turn over any exculpatory evidence. So they cite it in this letter saying, oh, we have this duty. But then if you also look at the paragraph where it talks about, you know, we're willing to file a motion protective order, they also talk about Federal Rule of Criminal Procedure 6, if you see that, in that paragraph. That's the rule that requires all grand jury material to be secret. So the U.S. Attorney's Office and the state attorney, district attorney knows it. They just can't willy-nilly turn it over. There has to be a court order.
Right. And I mean, just to sneak this in at the end. Oh, and also we consider misconduct by the prosecutor potentially exculpatory. So if you have any of that, turn it over to us too. Meaning if you got any dirt on us, let us know what it is so we can figure out how to fight it. That's what he's trying to do.
As you're going through this progression of letters, it's interesting to know who signs it. This one is signed by the first assistant district attorney.
The first assistant district attorney, right.
Right.
So that's his number one. Right. Lynn could be a guy or a girl, I don't know, but Lynn is Morrissey's first assistant, writing to the U.S. Attorney's first assistant. All right, May 18th, I think, was up here. I think it's the long one. Yeah. All right, May 18th. This is from the district attorney to the Office of Professional Responsibility to the U.S. DOJ. Do you want to explain what that is before we read the letter?
The Department of Justice maintains, basically it's the ethics office, the Office of Professional Responsibility, to make sure that prosecutors and government employees are ethical. And so if you have a complaint about, you know, they lied or they did something unethical or, you know, they're having an affair with a juror, whatever you want to talk about, that gets investigated by OPR, and OPR then makes a determination. Okay.
So basically any wrongdoing, this is where you'd send it. So it's sending a message, right? The fact that Morrissey is writing this letter to the Office of Professional Responsibility.
Right.
Investigation by the Office of the United States Attorneys for the District of Massachusetts. Dear Sir, Madam, I write to formally request that an ongoing investigation be conducted by the U.S. Attorney's Office for the District of Massachusetts to be examined by the Office of Professional Responsibility, and should the investigation continue, that it be transferred to another office without history of conflict, bias, and abuse of prosecutorial discretion as outlined below. The Norfolk District Attorney's Office has undertaken an extensive investigation into the facts and circumstances of the death of John O'Keefe in Canton, Massachusetts on January 29, 2022. The facts and evidence gathered, including more than 40 individuals testifying before the Norfolk County Grand Jury, led to the second-degree murder indictment of Karen Reed. Reed was the operator of the vehicle that, the evidence demonstrates, struck her boyfriend, Boston police officer John O'Keefe. O'Keefe was then left to die in the snow on the side of Fairview Road, Canton, during the evening of January 29, 2022. The case has been systematically making its way through Norfolk Superior Court with ongoing discovery still active and open, including motions under advisement and motions not yet heard. The defendant, through counsel, has been raising specious issues of a third-party culprit and complaints of witness and police misconduct as they attempt to confuse by offering not different interpretations of the Commonwealth statements, evidence, and positions, but inventing them out of whole cloth. No actual substance evidence supporting police misconduct or any federal violations have been identified by the defendant, the DA's office, or the Massachusetts Superior Court during the ongoing discovery process. Anything you want to add so far?
Well, just a couple things to point out. If we go back to the beginning, where he talks about a history of conflict, bias, and abuse of prosecutorial discretion. So basically, he's painting a picture saying, look, these guys historically are bad. Not that they're bad today. They're going to have trouble. They can't point to anything bad today, but they're talking at a history. And then when he goes down, obviously he badmouths the defense lawyer as he's going through this, and that no federal violations have been identified by the defendant.
Right.
He points that out, although he doesn't know that. And okay, go ahead. But that he doesn't know these things, but he's trying to paint a picture. He's just throwing it up against the wall and seeing what's going to stick.
Approximately 3 weeks ago, multiple state witnesses who had been brought before the state grand jury notified the Norfolk District Attorney's Office that they were contacted by the FBI and subsequently received subpoenas to appear before a federal grand jury. By the way, this letter is 9 days after the last letter, which can let you know probably that the last letter didn't have the result that they wanted it to, meaning the U.S. Attorney's Office turning over everything they asked for. So when they didn't get everything they asked for, then they followed up that letter with a letter to the Office of Professional Responsibility, which is just an interesting timeline. Shortly after those notifications, the DA's office sent a letter to Josh Levy, the first assistant to the U.S. Attorney, Lynn Beeland, to suggest that we were conducting an investigation that may involve a number of witnesses in the murder case. At the time, Attorney Beeland expressed some concerns about both the jurisdiction and the timing of any actions being taken by the United States Attorney's Office, as they could imprudently impact on ongoing murder prosecution of Karen Reed.
Can we stop there for a second? All right. If you look at that where it says here, shortly after these notifications to the District Attorney's Office, Joshua Levy, first assistant, contacted the District Attorney. So out of a courtesy, he didn't have to do it. The first assistant U.S. Attorney picked up the telephone, called the first assistant at the District Attorney's Office to let him know, look, we're out there interviewing these witnesses. And they carefully used the word suggested that they were conducting an investigation, which means that Levy didn't tell him we're conducting an investigation. So suggested. So he's being very careful in the way he's wording it, but he's admitting the U.S. Attorney contacted him before he contacted the U.S. Attorney.
There's also some interesting things in here, right? So number one, that almost sounds like the bump in the Adelson case, like they wanted to stir some feathers to see what the DA's office would do once they notified them that they were going to do this. Number one. Number two, at that time, Attorney Beeland, which is the first assistant district attorney, expressed some concerns about the jurisdiction and timing of the actions. Well, where was that in the letter? We didn't see the concerns about their jurisdiction in the letter. We just saw, hey, we know you guys are doing this. Just provide us with any information you have in case it's exculpatory so we could turn it over to the defense. But maybe it happened in a telephone conversation. I don't know. Based on the collective experience of several of my colleagues, Massachusetts district attorneys, and former federal prosecutor, it appears to be unprecedented for the federal government to step into the middle of an ongoing state murder prosecution prompted only by inflammatory and ethically dubious defense strategy. I would agree with him there, wouldn't you? It would be unusual if it was just based off that.
Well, the federal government puts their nose into everything.
That's true.
How many times have we seen, for instance, when we're having like riots or public demonstrations where you have the local prosecutors investigating it, but you also have the federal government walking in and conducting an investigation at the same time, talking to the same witnesses. This is not unprecedented, and it's I don't know if it's a bad strategy. That we've talked about this defense lawyer, and he said some things at that hearing that aren't borne out by these letters. but they have to attack the defense lawyer because they've assumed the defense lawyer is the one that filed the complaint.
Yeah. And I do think a lot of this is funny that the lawyer that's being accused of doing things shady and potentially under investigation is pointing at the U.S. Attorney's Office as being biased and abusing their power. They're looking at the defense attorney, calling them unethical and sleazy. Basically, it's like every lawyer in this case seems to be pointing to another lawyer. It's like that Spider-Man meme where everybody's dressed as Spider-Man pointing at each other like, no, you're unethical. No, you're unethical. No, you're abusing your power. No, you have prosecutorial misconduct. And it's like, this doesn't look good really for anybody, except for potentially defense attorneys, because they always get called slime balls. So it's like when there's actually some wrongdoing being pointed at between the prosecutors, they're playing what is it? You're playing in the slop with the pigs when
That's
you're
right.
getting into this finger pointing game. In the conversation with First Assistant Norfolk District Attorney Lynn Beeland, Assistant United States Attorney Josh Levy declined to identify what jurisdiction the federal government had in this murder case in what appears to be a highly unusual and possibly abusive exercise of power. Attorney Levy indicated that the U.S. Attorney's Office was still proceeding ahead with an investigation that would involve individuals who were active participants in the events and or witnesses in the case. Attorney Beeland reminded Assistant U.S. Attorney Josh Levy that in any statements and or testimony in such an investigation that pertain to any of the witnesses in the ongoing state murder trial may create an ongoing obligation for state prosecutors to provide defense with access to all information and statements gathered or recorded as a result of the federal investigation. Like he cares. It's like they're threatening the U.S. Attorney's Office with like, well, we may have to turn this stuff over to the defense.
Well,
U.S. Attorney's Office like, well, so what?
Well, you have to assume that the first assistant U.S. attorney is not a rookie.
Right.
This is not his first year at the U.S. Attorney's Office, and it's not the first time some state prosecutors called him up and chewed him out a little bit. So I mean, he knows what he is. He knows the power he's got, and he careless. This guy could jump up and down and do flips on top of his desk and wouldn't bother him.
And it's just like, and once this stuff starts happening, where a DA starts writing these letters complaining to the Office of Professional Responsibility, it's going to be tough to mend that relationship and have a good working relationship going forward, regardless of how much somebody doesn't care if somebody jumps up and down and screams at him.
I think the relationship is pretty bad already, because let me tell you what really should have happened if this was a good situation, a good relationship. The district attorney and the U.S. attorney would have met privately in one of their offices, had a cup of coffee, and talked about this. So to make this public and to write these letters and threats, this relationship is over before it started.
Okay, where was I? The U.S. Attorney's Office offered the opinion that you can't turn over information that you don't have. That's a good point. This position leaves state authorities potentially unable to meet the constitutional mandate expressed in Brady versus Maryland and corresponding Massachusetts state rules.
And that's really not true. Yeah. And that's not true. And that's just totally a misstatement of the law. Brady only requires them to turn over what they control. If they don't control it,
if they don't know about it, they don't have to turn it over. Obviously, you don't have exculpatory evidence. What are you talking about?
And you can't tell me this guy doesn't know that when he wrote that sentence.
This is pretty funny. Since that call concluded, we have confirmed that witnesses have testified before the grand jury. Rule 6 of the Federal Rules of Criminal Procedure allow that under certain compelling circumstances, information may be provided to all counsel, including those not before the federal grand jury. Recent court filings and statements by defense counsel in the Reed matter suggest that the defense attorneys were the source of the initial complaint and allegations prompting this action by the U.S. Attorney's Office. Well, that should let you know they're probably not stepping on your toes with the murder investigation, but they're investigating something else. Reed's defense counsel's recent court filings raise out of thin air and apparently purposeful misstatement of fact, unsupported claims of a cover-up by investigators and witnesses, including municipal, state, and federal law enforcement. As shown in attached documents, many or all of these unsupported allegations can be vetted and reviewed by the judges of the Massachusetts Superior Court during the discovery and motion sessions or available appellate review. By the way, if you really did nothing wrong and you had all these documents and it was an easy open and shut case, or we've had an ethics complaint that a client's had against us, they get closed like that. Immediately they get closed if there are unsubstantiated claims made like this with nothing to back them up, and they are just wild speculation that a defense attorney is throwing up against the wall. I am unaware and strongly doubt any prosecutor or state police misconduct in this case. Well, if he said it, then I guess it must be true, right?
Right.
The only allegations to that effect have been in unsupported news claims or defense filings that had not even been answered at the time AUSA Levy confirmed the existence of a federal grand jury. And by the way, I'm not saying there is misconduct because I have no idea. I'm just saying this letter gives off a vibe of there's something you're scared of as the district attorney's office if you're going through all of this just because some defense lawyer said that you covered something up or that there was prosecutorial misconduct.
And honestly, defense lawyers say that all the time.
Agreed.
So, I guarantee you that, every time a defense lawyer says it, the U.S. Attorney's Office does not open a matter and send out FBI agents to do interviews. There's more.
Right. And that's the point is like, just in cases we've covered on YouTube, defense attorneys have accused prosecutors of prosecutorial misconduct. We don't usually get a DOJ investigation, though. It raises the question why the apparatus of the DOJ would intervene, even as such issues are still being assessed by a justice of the Massachusetts Superior Court without some additional impetus on the part of the U.S. Attorney's Office. Without dismissing the important role of the DOJ in investigating allegations of police misconduct and federal violations, we bring to your attention what appears to be additional concerns concerning motive, conflict, or appearance of conflict and potential bias of the Office of the United States Attorney for Massachusetts, which might explain these unprecedented proceedings. Now, it's also in the realm of possibility that this DA is correct and this U.S. attorney is biased and conflicted and has bad motives. I mean, that's a possibility too, right? I mean, it is.
Well, it's possible. The point is that bias affecting what they're doing? And he also calls it potential bias. He still hasn't been able to point to anything specifically that was wrong or done improperly. He just doesn't like the fact they're investigating. That's all it boils down
to. I predicate the following information with the fact that it has been the policy of the Norfolk District Attorney's Office during my 12-year tenure as DA to maintain a close working relationship with the U.S. Attorneys for Massachusetts. Notable in that relationship was the cooperation of the Norfolk District Attorney's Office in the prosecution of a 35-year-old murder case that was committed in Sharon, Massachusetts, which involved the Whitney Bulger gang.
Bulger. Organized crime.
The Norfolk District Attorney's Office had statutory jurisdiction to pursue the case, but in the interest of cooperation, acceded to the request of the U.S. Attorney's Office at the time to allow federal prosecution to proceed with the case. As a result of that agreement, the Norfolk District Attorney and Massachusetts State Police assigned to the Norfolk District Attorney's Office worked closely with the U.S. Attorney's Office on the case. During this period, AUSA Dustin Chow, without nexus to that prosecution, asked a Massachusetts State Police detective involved in the matter if he had any kind of damaging information on the district attorney, first assistant, or the Norfolk District Attorney's Office. This sua sponte question was not without context. Laura G. Chow, Dustin's wife, had been an employee of the Norfolk District Attorney's Office prior to the case mentioned above. Not long into her tenure, it became apparent to her supervisors that she required more seasoning and legal experience if she wanted to succeed in a superior court role. She was offered the chance to gain more trial experience in the district court without any loss of compensation. Instead, she resigned and filed an ethics violation complaint with the Massachusetts Board of Bar Overseers against the first assistant in the Norfolk District Attorney's Office. The complaint before the board was summarily dismissed in short order. Laura G. Chow was instead cited for a violation of her ethical obligation to provide accurate address information for her practice. Long after separation, she was misrepresenting her address as the Norfolk DA's office. So the U.S. Attorney's wife worked for this DA's office and basically was fired or quit because she wasn't promoted. And they're saying this is all retaliation.
Actually, an assistant U.S. Attorney's wife.
Okay.
Not the U.S. Attorney.
Okay.
An assistant U.S. So just one of the assistant's wives. One of the assistant's wives had a problem. And you go back up to this 35-year-old murder case, by the way, that's Whitey Bulger. Whitey Bulger is a famous organized crime figure that the FBI took down. It was a federal case from beginning to end.
So even if they wanted to block it, they wouldn't have been able to.
The U.S. Attorney's Office is the one that should have handled it from beginning to end anyway. And even though they're showing that maybe she didn't like the district attorney, okay? Let's agree she didn't like the district attorney. How is he connecting that up to this investigation? There's no connection. He hasn't connected it up. In Boston, by the way, the Boston office is not a small U.S. attorney's office.
Right.
I mean, that's a pretty big,
So
office.
just one assistant, like they're going to do all this because one assistant U.S. attorney's wife had a bad experience there. I mean,
yeah, I'll bet you they have 100 assistants.
I have no idea.
Yeah.
I began composing this letter well before May 17th publication of the DOJ Office of the Inspector General Report 23071, which has apparently prompted the resignation of the current U.S. Attorney of the District of Massachusetts. My attention is drawn to several portions of Section 2, particularly as they pertain to the weaponization of the U.S. Attorney's Office for personal, political, and retributive purposes. Will regret the day, sorry, this is from page 46. Hayden will regret the day he did this to you. Watch. We asked Rollins whether her disclosure was retribution for the wrongs she believed Hayden had committed. Additionally, we determined that days after Hayden prevailed in the September 6th preliminary election, Rollins sought to damage Hayden's reputation. The evidence demonstrated she used her position as U.S. attorney in an ultimately unsuccessful effort to create the impression publicly that the DOJ was or would be investigating Hayden for public corruption. So again, wrongdoing on the prior or current at the time, in transition here, U.S. attorney having nothing to do with this case, like you said. So yes, it's kind of like in Murdaugh, the clerk of court, they have all this bad stuff she's doing. Can we connect it to the Murdaugh case? Seemingly there seems to be some connections here. Unless I'm missing it, do you see any connections between these citations and the resignation of the U.S. attorney in this case?
He hasn't. There's no what we would call a nexus. There's no direct connection between any of this and the investigation he's talking about.
And if there were, you better believe it would be in these letters.
Absolutely.
These DOJ findings and questions reinforce my belief that the U.S. Attorney's Office for the District of Massachusetts must be removed from whatever investigation is being conducted into the Reed matter. Whatever. It doesn't matter what it is. They have to stop. I believe that a reasonable person could conclude that the same type of tactics are being employed against the Norfolk DA's office in the Reed investigation. The outgoing U.S. attorney has made no secret of her personal animosity towards me, including repeated crude, outlandish personal and professional attacks against me in the media during her time as Suffolk DA. I guess the U.S. attorney was previously the Suffolk district attorney, right? That's what that sounds like.
That's what it sounds like. Yeah.
The head of the public corruption unit has raised the specter of personal retaliation for his wife's departure from the Norfolk DA's office. The public has the right to a U.S. attorney's office that is fair and unbiased as it executes its responsibilities. Weaponizing the U.S. attorney's office to conduct an unprecedented intervention into an open state murder case appears to raise the same concerns outlined in the DOJ's report. I submit that the pattern of using the U.S. attorney's office for personal purposes established in Report 23071, coupled with the obvious conflict of AUSA Chow, make it impossible to conclude that a fair evaluation of the unprecedented Reed intervention can be conducted by any party within the Massachusetts office. It is impossible to determine how far the tentacles of bias have spread out from the chief of the relevant unit and the titular head of office.
Titular.
I formally request that an impartial federal official unaffiliated with the U.S. Attorney's Office for Massachusetts review and investigate the steps and actions that are being taken by current members of the Did you say something?
No.
Of the Massachusetts office, exploring this apparent bias and whether it predisposed them to abuse their prosecutorial discretion in this matter. In the unlikely case that an impartial review finds that a DOJ investigation into the Karen Reed matter is appropriate, even before the issues at hand have been vetted by the Norfolk Superior Court judge hearing the case, I request that the investigation be reassigned from parties with clearly stated and documented bias against members of the Norfolk DA's office to attorneys entirely outside the office of the United States Attorney for Massachusetts. Okay, so he doesn't want the investigation to completely go away, but maybe just new people investigating them.
Well, what he's hoping was it's going to go away. And you know how he talks about he had 12 years of a great relationship? That's in conflict with a couple paragraphs above where he says that the U.S. attorney and he hated each other, apparently.
Before she was even the U.S. attorney. So,
right, before she was the U.S. attorney.
Which obviously, if she was the DA, he wasn't the DA. So the timeline doesn't match up. Why lime and the coconut? Canton resident here. You wouldn't believe the show that has engulfed this town. Thanks for covering this. What an embarrassment for the DA. Yeah, I know. And I realize we don't know the half of it. We don't know the half of it yet. Netwoman has gifted not 20, but 40 memberships. That's awesome, Netwoman. Turning the entire chat green, as they like to say, which is awesome. Okay, now we have the U.S. Department of Justice writing to Michael Morrissey. This is the letter from the U.S. Attorney's Office to the DA, June 1st. June 1st. The Office of Professional Responsibility received your May 18th letter requesting that OPR investigate the decision by the United States Attorney's Office to subpoena individuals who are witnesses in your pending state prosecution to testify before the grand jury in an ongoing federal investigation. You stated that the U.S. Attorney's Office investigation is possibly an abusive exercise of power and likely based only on defendant Karen Reed's specious claims of witness and police misconduct. In addition to an investigation of the U.S. Attorney's Office investigative decision, you requested that OPR transfer the U.S. Attorney's pending investigation. Something's going on with your thing, Dad. It's echoing.
Yeah, I know.
All right, I'm going to mute you. I'm going to mute you just while I read this, and then I'll bring you back up just so I don't hear myself reading it. In addition to an investigation of the U.S. Attorney's Office investigative decision, you requested that OPR transfer the pending investigation to another office without history of conflict, bias, and abuse of prosecutorial discretion. OPR has jurisdiction to investigate allegations of misconduct involving the Department of Justice attorneys that relate to the exercise of their authority to investigate, litigate, or provide legal advice, as well as allegations of misconduct by law enforcement personnel that are related to allegations of attorney misconduct within the jurisdiction of OPR. However, it is the policy of this office to refrain from investigating such issues or allegations if an active investigation is ongoing or litigation is pending. With regard to your request that another office be assigned to the pending grand jury investigation, a matter outside OPR's jurisdiction, OPR forwarded your complaint to the Executive Office for the U.S. Attorney's Office for whatever action it deems appropriate. Further inquiry, you can ask somebody else, basically. All right, what did you take from this letter?
Well, the one line, which is the line, is we don't interfere with ongoing investigations. Think about how they could shut down the investigatory process if someone just said, let's just send a whole bunch of letters to OPR, and then we'll interfere with what an investigation going down, so we'll drag it out. So that is absolutely the policy, and it's always been the policy.
John said, if an officer is killed outside of another officer's house, wouldn't the obvious choice to handle the trial be outside of that county or state? So not necessarily, because you can't just be like calling a neighboring state being like, give me your resources to investigate this. It's the same reason why, you know, the DA's office can't just say, we don't want this U.S. Attorney's Office investigating us. Why don't you call the Middle District of Florida and see if they'll investigate us? It's not really their job. You know, so every jurisdiction and place has a job, but there does become issues when a police department is so involved. And I don't know, again, I don't know if it's the same department, if a different department is investigating this, I don't know. But if they're that intimately involved, you would think somebody else should do this investigation.
And, you know, it's fact driven on all these, whether or not there's a conflict or not, whether somebody, because a lot of times you have state law enforcement that will come into a county to do something like this, like we have FDLE in Florida Department of Law Enforcement that could come in, but it's all fact specific. You can't say as a general rule that should happen.
Right. I agree. All right. Now we have June 12th. So 3 days later, US DOJ from Josh Levy, the first or acting U.S. attorney at this point, because the old U.S. attorney is out and he used to be the first assistant. And he is replying finally to the, I think, May 9th letter to Lynn Beelan, the first assistant district attorney. So many first assistants and assistant and U.S. and district and all this stuff. What were you going to say something?
Yeah, I didn't mean to interrupt your thoughts, but that really long letter that we talked about from the district attorney, remember the first one was signed by his first assistant?
Right.
That really long letter, that was actually signed by the district attorney. He signed that one himself.
Right. That's this one. This is the really long one for the Office of Professional Responsibility.
Right.
So he wrote that himself. All right. So now let's get to this June 12th. This is from Josh Levy, the assistant U.S. attorney, to the assistant district attorney. Thank you for your letter dated May 9th. My apologies for the delay in responding, but I have been tied up with transition issues, meaning transitioning the old U.S. attorney out, and he is now acting attorney or U.S. attorney. We understand your office has important discovery obligations in any criminal prosecution. At this juncture, we have no issue with you advising the defense counsel about the contact we have had with your office and the information we have shared if you determine such a disclosure is warranted under Mass Rule of Criminal Procedure 14. We are mindful of the important concerns raised in your letter and will be back in touch with you as circumstances dictate. Translation: you go ahead and do what you got to do. We're going to keep doing our job. You keep doing yours. And if you want to bring that defense attorney in, go ahead. It seems like you guys have a really great working relationship, right? Like, what a threat that is. Oh, we're going to have to tell the defense attorney. It's like, go for it, dude. Go for it. Anything to add to that one?
No.
All right. We're looking for June 21st now. Here we go. June 21st. This is from the Commonwealth, signed by Lynn Beeland. To Jack Macklin, General Counsel of the Executive Office for the United States Attorneys, which is where the Office of Professional Responsibility said, this is where you need to send that complaint, not to us. So this is them sending the request here to have somebody else handle it. This letter is to inquire about the status of a request for a transfer of investigation due to a conflict of interest. The Norfolk District Attorney's Office sent the DOJ Professional Responsibility a letter raising concerns of potential investigation by the U.S. Attorney's Office for the District of Massachusetts involving witnesses relating to a pending state criminal matter, the Karen Reed matter. This office has subsequently received a June 1st letter from Jeffrey Ragsdale, counsel for OPR, reflecting that the extent that the letter indicated that the pending grand jury investigation should be reassigned, the appropriate office to address would be you. This is to inquire the status of that request and provide contact information for any further information you may require. If you have any questions or are looking for any additional information, I may be contacted as set out above. So it's basically them just taking the steps because they're basically unturning every stone to try to get somebody else to handle this investigation. And I do think it's worth pointing out, they have this Executive Office of the United States Attorney's Office for circumstances where it actually may be warranted that somebody else should handle this investigation if it's not appropriate for the U.S. Attorney's Office to handle this investigation, right?
Right. Actually, the Attorney General will be the one making the final decision on that.
And
the
so,
Attorney General themselves, right?
And so if there was a problem here, somebody would be there to look into it.
Right.
All right. June 21st. Next one is August 3rd. Here we go. This one is from the general counsel from that office that they're applying, what is that? June, July, August, a month and a half later. This responds to your June 21st letter concerning your putative request for a recusal of the United States Attorney's Office. As you indicate, the DOJ Office of Professional Responsibility informed you that they had referred your May 18th letter to my office for whatever action I deem appropriate. Consistent with the terms of the referral from OPR, I contacted acting U.S. Attorney Josh Levy, who we've seen in a bunch of these letters. Based on my understanding from that discussion with USA Levy, his office has a very different opinion of the circumstances in this case than as presented in Mr. Morrissey's letter. Shocker there. Two completely different sides to this story. His office has not reached any official determination whether prosecution is warranted, but they believe it is essential to continue their investigation given the information on which they are aware, which tells you there is more there than just some crazy defense attorney making wild allegations with no factual backing, right?
This is the worst letter for the district attorney than all of them. Here we have an independent guy. This guy's sitting in Washington, D.C. I mean, he's no rookie either. He's the general counsel for the executive offices of U.S. attorneys. And he has reviewed the information from U.S. Attorney Levy. He's reviewed it, and he found Levy is doing just fine. So, if I was them,
almost like I agree with him.
Yeah. Well, he is agreeing with him. He does say there's enough there to keep going, and that should make the district attorney sweat.
Let me read this real quick, and then I'm going to ask you another question. At this time, we see no basis for a recusal in this investigation. So that right there tells you that the state attorney has written. I mean, how many letters have we read so far? I mean, they've written 3 or 4 letters making all these accusations against the U.S. Attorney's Office, abuse of power, biased, conflict of interest, all this stuff they're stating as fact. And this guy, just so we're clear, doesn't work for the Massachusetts State Attorney's Office. He's basically working on all United States attorneys, right?
The whole country. The whole country.
Yeah. So it's like they ask this guy to come in and he's got no dog in the fight. If the U.S. Attorney's Office is doing something wrong, he wants to fix it because that ends up looking bad for everybody. So he comes in, he reads the letter so he gets the DA's side. He talks to the assistant U.S. attorney or the acting U.S. attorney, gets his side, and he's like, oh, all right, you guys do what you need to do. I don't see any reason for recusal, but this is the process that it's supposed to take if there is an issue. So I'm glad to see that. The district attorney's office had an issue. They asked Office of Professional Responsibility. They asked the executive office for U.S. attorneys. They asked everybody they could possibly ask, and everybody basically told them, we're not going to do anything.
Peter, honestly, I have never seen the executive office do anything about a complaint like this, ever. This was a total waste of time by the district attorney because they're never going to get a U.S. attorney's office recused from doing an investigation. It doesn't happen.
Unless there's something obviously horrible going on.
So corrupt. It's got to be total corruption.
Right? Exactly. So, I mean, but to get this in writing, to get this negative action in writing is not a good thing for the DA's office.
It should have been the headline of the newspaper in Boston. I don't know if it was or not, but it should have been.
Well, I think they've got some hearings coming up, and my guess is they're going to just run a truck through this. All right, October 12th. So now we've got a couple months. I don't know where this one will be. So let's see here. This is June 21st, November 22nd, October 12th. Here we go. So this is, again, from who signed this one, Lynn Beeland to Josh Levy. And this would be 2 months after they got notice from the executive office that they're not going to force the U.S. attorneys off this case. All right, this is a follow-up on our previous communications dated May 9th and your June 12th response. On September 15th, the Norfolk Superior Court set a trial date of March 12th, 2024 on the indictments for second-degree murder, manslaughter while operating under the influence, and leaving the scene of personal injury and death. Under the Massachusetts Rule of Criminal Procedure, mandatory discovery includes items of information within the Commonwealth's possession, custody, or control relevant to the case, including statements by the defendant, Karen Reed, statements of persons who testified before a grand jury, and grand jury minutes, facts of an exculpatory matter, material and relevant police reports, photographs, and tangible objects, reports of physical examination of any person, and scientific tests, experiments, and statements of persons intended to be called as witnesses, and disclosure of promises, rewards, or inducements made to witnesses the party intends to present at trial. The Commonwealth also has a duty to notify the defendant of these items that are known to exist but are not within its care, custody, or control. To effectuate our discovery obligations, we're requesting statements to investigators and grand jury minutes of witnesses in your investigation, as well as, to the extent that may exist, any other above described items or materials. Given the impending trial date, prompt disclosures are critically important. So again, they're basically asking for the same stuff. They're giving the same reasons. The response will be the same. This is just more of the same, right?
Right. More of the same.
If there is need for limited disclosure of such items, please include such a request. We are willing, with the appropriate foundation, to file a motion for protective order. Okay, same thing. Similarly, we will facilitate the process of the request for authorization from federal district court judge. Additionally, this office has constitutional case, literally the same exact thing. Okay. So that's on October 12th. Now we're looking for November 22nd. And now this is to the FBI from Michael Morrissey, the DA. Dear Special Agent Cohen, it was a pleasure to meet you at the State House for the Governor's press conference on hate crime enforcement. I wanted to again extend my welcome and best wishes to you in your role as the Boston Special Agent in charge, and look forward to working with you in the future. I also wanted to review this office's offer for your agents to speak to the state police who were involved in the John O'Keefe Canton murder investigation. My first assistant district attorney also mentioned our willingness to talk to the FBI, to the acting U.S. attorney in a recent phone conversation. If you would like to have your investigators talk to the state police, they can contact Detective Lieutenant Brian Tully. So what do you garner from this?
He's trying another route. He's just trying to go through the new SAC. The guy is new. Apparently, you can tell from that he just got appointed to be the SAC in Boston. So he's hoping, he doesn't really know what's going on, so maybe he can snooker him.
And he's basically saying, I don't know if I'd say snooker or use such strong language, but I think that he's definitely trying to be like, hey, come over here, do a little investigation as the FBI so we can present it and say, look, the new guy that's unbiased finds no wrongdoing in my office. I'm a good, high, powerful friend. I'll scratch his back a little bit. Hopefully he scratches mine. And I think he is definitely trying to get somebody else involved to give a report that says all clear in the Norfolk County District Attorney's Office. All right, January 12th. Here we go. So this was the letter that I believe was read or referenced in the hearing. And this is from Adam Deek, Assistant U.S. Attorney. Dear Justice Cannon, with respect to the above captioned matter, we received notice via a letter dated January 9, 2024 from counsel for the defendant regarding the Commonwealth's motion for protective order pertaining to Commonwealth notice discovery pursuant to Mass Rule of Criminal Procedure 14A1E1 with associated 6 amendment attachments. We additionally received copies of the motion, the defendant's opposition, and related filings, including copies of the 8 letters at issue. We are also aware of the upcoming hearing scheduled for January 18, 2024. We appreciate the opportunity to be heard on this issue. Having reviewed all the materials referenced above, the DOJ and U.S. Attorney's Office for the District of Massachusetts do not object to the public disclosure of the correspondence at issue in the pending motion, which was, in fact, these 8 letters we read today. And we told you that was a bad sign. So this person, Adam Deet, signed for Joshua Levy, the acting U.S. attorney. So that is a bad sign for the state. It also, multiple things throughout these letters have told me this U.S. attorney's office seems to have a more respectful and better relationship with Karen Reed's attorneys, the defense attorneys in this case, than they do with the prosecutors. Because it seems like they've been talking, and it seems like they've talked here as well. What do you think?
Well, I wouldn't read that into it. I would say they received enough information to open up a matter and do an investigation. It may be, I don't think it was just from the defense attorney, but I think there's some other stuff that they're looking at. Plus, they knew that this letter was going to be written because I think they drafted all their other letters knowing that there'd be public disclosure. That's what they suspected. That
You should always suspect that.
That's right. This district attorney was going to sell them out. So let's write letters to make sure we cover ourselves that are going to go public. And as I told you, as we talked about the last podcast we had on YouTube, these letters, this is it's unusual for a U.S. attorney or assistant U.S. attorney not to be in the courtroom when there is an issue that involves the U.S. Attorney's Office and disclosure of U.S. Attorney's Office information or correspondence. They were invited to be there, and they chose not to be there. So that just shows you they're just leaving this district attorney to swing in the wind. And there is no love lost between these two groups.
And that's what I'm saying. It's not necessarily that they love these defense attorneys or that they're best friends or anything like that, or they're helping them out, but it just seems like the relationship is so bad between the U.S. Attorney's Office and the DA's office that it might actually be better with the defense attorneys.
Yeah. There's obviously a bad relationship. You're
Ashley said, thank you for breaking this down for us. What's your biggest takeaway from these letters? What would you say?
First off, these letters did not verify that there was an investigation being conducted of the district attorney's office. You don't read that anywhere in the letters. The defense lawyer said that in court, saying the district attorney is being investigated. Nowhere in this letter does it say that. So I think that that's a bit of an exaggeration by the defense lawyer. And that's really what I take away from this is the defense lawyer is exaggerating what's said in these letters.
Yeah, I think it's a combination of the defense lawyer is exaggerating, but the defense lawyers and the district attorney both take the same inference from this, that it's not good for the district attorney's office.
Oh, yeah.
Yeah, that's what I kind of think. And Iris asked this question, isn't the defense mischaracterizing the investigation if there's no targeted investigation against the Norfolk DA in the Reed case? Exaggerating probably more than mischaracterizing, but I mean, I think it's a fair question.
Oh, it is. It is. And
Yes, they're exaggerating. I wouldn't have said what that defense lawyer said.
Yeah, me neither.
Yeah, he really went beyond the scope of propriety. There's enough in these letters for him to make the point without actually exaggerating.
He could have just said, I mean, the DA's office is making wild accusations that nobody is corroborating and nobody is agreeing with. Even unbiased parties come and look and don't agree with what they're saying, calling everybody unbiased or calling everybody biased, everybody slinging wild accusations. They say that we're doing all this stuff, and then people come in and look at it and don't agree with them because that's what happened.
And I'd waive that letter from the executive office.
Exactly.
That said, we've looked into this and there's enough to keep investigating this case. So I would tell that judge, there's something going on here. And I think that we need to know about it. My client can't get a fair trial unless my client is exposed or at least gets all these statements from witnesses or gets this grand jury information.
And I would combine it with the letter where they say, I can't believe they're even looking into this. All they have is the defense attorney saying stuff, and defense attorneys don't know anything, basically. So I would combine those two letters. Yeah. Net woman, sorry if you said this before. How exactly did the defense get a hold of these letters? I think they were turned over from the DOJ, right?
No, they were actually turned over by the district attorney. Remember, the district attorney said that they gave copies already to the defense lawyer.
Okay. Yeah. I remember reading. I didn't remember which lawyer said that.
At the hearing, the prosecutor, the district attorney, gave the letters.
Okay. Provocateur libertarian. You look so much like your dad, but he looks like more of a hard A. It's probably true. Probably true. I'm nicer. John O'Rourke. Doesn't it seem like allegedly something squirrely happened internally with the police department? I think it should be pushed to a different state, in my opinion. They can't really just do that all the time. You can't just like push investigations to different states. That's not really how our nation is set up. And just to say that the whole state would be biased, then we don't really have a justice system, right?
But you do have the FBI, and
right.
Apparently they're out there interviewing people, so they're not subject to influence by the local police department.
And the U.S. Attorney's Office for Massachusetts is not a state actor,
right?
They're a federal actor,
and not an elected official,
right? That's the point of the federal,
right?
Tiger 2. This is fascinating. Abuse of power, lies, investigations. I'm making popcorn and putting on slippers. It definitely feels like The Town, like one of those movies where it's out of Boston and all these people sound and look the part when you hear them. I mean, it's going to be wild if this thing does go to trial in March. It's definitely one we're going to follow. Sandy, this trial seems like the plot from the movie The Departed. Excuse me. I didn't know this comment was coming. I said The Town. She says Departed, which coincidentally took place in Massachusetts. A lot of movies like this took place in Massachusetts.
Right.
So it's not so far-fetched, I guess. But this is really, really interesting to me. And they said the letters were also, I just lost that. Somebody said the letters were originally published in Boston Magazine. Pretty interesting. All right, let me see if we have any more questions before we bounce. We're right at the 1 hour mark. Samantha said, Peter, you're obviously super smart, but I love that even you mispronounce words and your dad is there to correct you. Dads are the best. Whoops. I could just take them off the screen so he can't correct me. Even if you mispronounce words, dads are the best. Always learning from them. Titler. Yes. Dude, there's so many words I mispronounce in these documents, especially because I'm reading like 100 pages. I feel like, so it's just wild. Another show following. Yes. What is it on? I can't remember. Oh, Delphi. Okay. Sorry. I forgot. And I also, John is probably texting me. Yeah. Sorry. You're going to have to bump it again. I wasn't paying attention to my text messages. We were just dug in here. Delphi. Dad, quick thought on this. So Delphi case is a murder case, years old. Years and years later, they arrest this guy. His lawyers file all these motions, say it's this cult. They accuse somebody else, wild, police screw ups, all this stuff. Judge throws them off the case because some documents, pictures of the crime scene were taken from their office by an employee, disseminated into the media. She says that's gross negligence. You can't be on the case. You're incompetent. You're out. Doesn't really let them even argue, doesn't do it in front of their client. So she basically threatens them that she's going to embarrass them and ruin their career in front of everybody if they don't withdraw. So they withdraw, and then orally, but then later they're like, actually, we don't want to withdraw. We want you to be recused. She kicks him off anyway. Criminal defendant writes a letter saying, no, I want these guys to be my lawyer. I'll waive any conflict. They say they'll do a pro bono, even if she won't allow him to be appointed. She says, too bad, you're out. They in the middle of the case, appeal it up to the Indiana Supreme Court. Indiana Supreme Court says, no, they're back on the case. They come back on the case. She immediately denies all of their motions, even though prior she said, basically the attorneys that were there prior, she said she was going to let him have hearings on some of these motions. Now, no hearings, just denied. What do you think?
That's bizarre.
I know, it's crazy.
I mean, that is crazy.
I mean,
that judge should be removed.
I mean, it's like she doesn't care. It's like she thinks she's untouchable or something at this point. It was literally right after they were put back on the case. They asked for her to be removed. The Indiana Supreme Court did not remove her. And before they could even file their new motion to remove her as the judge, she's ruled on all these motions without hearing.
Well, that judge should be removed. What she should have done is just punish the lawyers. She could have fined them or
sanctioned them, whatever.
Ethical violation, something. But that guy's allowed to have the lawyers he wants to represent him.
You would think.
You know, and this judge is supposed to be unemotional and is supposed to be a neutral. Boy, it sure doesn't sound like it.
Yeah, so I deep dive into that order coming up next. You should redirect to it if you have autoplay on. So everybody from this chat should go in there. We have one more question. Reed attorneys also said the feds are going to be releasing info to both parties because they cannot allow this case to go to trial. What do you make of that?
I do not remember ever seeing that. And that would be a very unusual statement for the feds to make. But
if all this is going on, I would be surprised if this case goes to trial in March, right?
Oh, yeah. You know, that's true. But the feds aren't going to interfere with the trial date directly. I mean, they may do it indirectly by releasing information, but they're not going to actually, show up in court or delay a trial.
Yeah, exactly. All right. That's all we got, Dad. Thanks for joining me.
Sure.
I will talk to you later, and I will talk to everybody else later. We're out of here. Stick around for the Delphi Deep Dive. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.